So tonight's guest speaker is Mark Stanziola. Mark is a family law attorney with over 31 years of experience representing clients in matters ranging from divorce to property distribution and a whole lot more. He's a magna cum laude graduate of the University of Scranton and a graduate of the University of Pittsburgh Law School. He's also been very active in supporting the LGBTQ community, including serving on the board of directors of the Bradbury Sullivan LGBTQ Center in Allentown, PA. Tonight, he's going to be speaking about life planning for trans and gender diverse individuals. So please welcome my friend, Mark Stanziola.
Thank you, Corinne. It's nice to be here. I'm glad I can do this. As Corinne said, if you have any questions, chat her. She can interrupt me, or we can save questions to the end. So what I'm going to talk about more or less is what I consider the necessary things that every person should have, whether you're trans, gay, straight, married, or single. And I'm going to try and tailor it a little bit to the audience and add in some things that I believe maybe a trans person would want to know. And anybody can, ask me questions about it. Corinne can maybe embellish upon what she, if she has any questions or if she thinks I didn't cover something. So I've been practicing about 34 years, and it still amazes me how many people don't make any plans for what happens if they die. I was telling Corinne before we began, I think there's a misconception that if you plan for a will or what happens to your estate after you die, it could hasten your death. And I always take the position when I talk to people, it would have the opposite effect, because now you're ready for it, so it ain't going to happen. So the documents I always recommend, and again, this is generally for everyone, no matter what your life situation is. The first thing would be a will. A will is pretty much a document that, everybody understands. You write it out and it lists what you want to go to whom. Wills can be as generic or as specific as you want them. The important items of a will are that it should address generally specifically who you want to take control of collecting your assets and dispersing your assets once you've died. The will has certain provisions in it that act as a power of attorney that would go to the person you designate as what we would call your executor or executrix. And basically that person is then charged with a fiduciary duty to make sure that your wishes are carried forth. So it's really important that you give some consideration to that. That's the most important thing probably about what you could do with the will, is make sure the person that you are choosing to be your executor knows your wishes, knows you, knows what you would want, and isn't really necessarily making any decisions, but is carrying forth the decisions you've made. So kind of rules of thumb for picking an executor: it should be somebody who is not really older than you, because you're gonna hope that this person is still around long after you've departed. It doesn't have to be intensely younger than you, but a peer or somebody around your age or somebody a little younger. I wouldn't pick like an aunt or an uncle that's 30 years older than you, because that doesn't really make a lot of sense. If you have a spouse or a life partner, generally that is the first choice for your executor. If you don't have that, you pick a friend, a family member, a confidant, somebody that you trust. This person doesn't have to have any special skills. The only skill they really need to know is they need to know you pretty well, and they need to know that once you're gone, that they have to do something. They have to open up an estate. They have to go, if they can't do it on their own, they have to know that they have to go to an attorney, go to a law office, go somewhere, go to the recorder or the Register of Wills office, get information. The executor, basically, if you go to an attorney's office, the executor is going to just give the will over to the attorney, and the attorney is going to probate it. What probate means is a fancy word for file it of record. When you execute a will, it doesn't go anywhere. It stays with you or stays in a safe place until you die.
So if I have a will,
yes,
I should have a copy, and my executor should have a copy as well?
should. An original is what the court is going to want unless the original cannot be located. And sometimes you see advertisements in newspapers and legal journals saying anybody associated with the estate of, if they know of the original will. If you can't find the original will, the court will defer to a copy, but they would prefer the original. It is a good idea to keep a copy, or have your executor have a copy, even if it's in a sealed envelope, or at very least, let your executor know where you keep it in your important papers. And it shouldn't be kept, not too many people have safe deposit boxes anymore, but that used to be pretty common. Everybody kept their wills and other important papers in their safe deposit box. That's a bad idea for a will, because the minute you die, the bank has to seal the safe deposit box. So if the will's in the safe deposit box, you have to go to court, get a court order to open the safe deposit box to even start the process. So it's just an unnecessary delayed complication. So my suggestion to my clients is generally go to Home Depot, go to Lowe's, go to Walmart, get a $25 fireproof box, keep it with the other important papers in your house, and just let the person who is your executor know where it is, and know in case something happens to you, that's where they should go and that's what they should look for.
Okay.
So the will is going to name an executor. You should probably have a backup executor, an alternate executor, somebody if for some reason that person is disabled or incompetent or dies, unexpectedly, before you, and you never change it, that takes that person's place. And that the rules for that person should be the same. They should be a person you trust, somebody who has some wherewithal, that isn't scared of the legal system, that isn't scared of dealing with authority figures, in the sense of they have to at least go to the courthouse to do a few paperwork signing and things of that nature. The will in and of itself, the most important thing is picking the executor. Once you pick the executor, then you have to determine how you want to divide up your estate. Your estate can go in any percentage, any share, to whoever. If your spouse or your life partner or whoever is going to get everything, then everything goes to them. If you want to divide your estate between several people, you can do that. That is your choice. You also have to make a decision that what happens if one of the beneficiaries in your estate dies? Does their portion revert to the rest of the beneficiaries, or does it go perhaps to that person's family, their children? And those are things that an attorney will go over with you. But the bottom line is that you kind of have to have an idea of who should inherit your property. You don't need to be super specific in what property you're distributing to your estate, unless you want to be. If you have something that's very precious to you, jewelry or a watch or something like that, that you want to go to a specific person, and you want to make sure that that wish gets carried out come hell or high water, you can list it in your will and say, my watch goes to my nephew, George.
So we have a quick question here, Mark, is around the fireproof box.
Yeah. And
there's a combination or a key lock. Is there a better option? I guess
that doesn't really matter. I mean, the thing about a combination is that, that's your degree of how secure you want it to be from prying eyes, I guess.
So I guess I think about in my case, so we have a fireproof lockbox, and I know where the key is. My wife knows where the key is. Our kid should know where the key is, but he forgets stuff. Yeah. So I'm guessing that somebody's going to go at it with a crowbar.
Yeah. Well, they're not that hard to get open, to be honest with you, if you really needed to. It's more about that they're protected in case there's a flood or a fire.
Yeah.
And I guess the amount of security you want to put on it is your own personal preference. If you don't want somebody else snooping in your personal items, that may or may not have access to it, then get a combination lock and just make sure that the combination is known by the executor so that the person who needs to open it can open it. If they can't open it, the lock will be broken and the box will be open. My husband and I have just a key lock because there's nothing secret in there. And we just have it locked, and we really even don't have it locked. We just have it closed and the key is in it. So there's no big deal because there's nothing in, everything goes to each other than our son. So there's nothing,
Right.
there's nothing really that I would worry about.
You were
Go ahead.
talking about last wishes, right?
Mhm.
And I know for myself as a person of trans experience, and I don't think I really have this issue personally, but I know I've thought about it, is that if so my wife is my executor
Right.
and inheritor, and then if the two of us died simultaneously in a fiery car wreck, then everything goes to our son and he's executor. But I guess there's the possibility that the three of us could die in a fiery car wreck, and then there's no then I guess the court is going to have to decide
You
everything.
can appoint as many alternates as you want. So if you think that's a realistic possibility, you could have your wife, your son, and a third or a fourth or a fifth.
So
And
I
it
guess
would
my area of concern is that I want to make sure that my headstone says Corinne
right.
and not my dead name.
Right. So what you would do is you would specifically spell that out. There is the will itself has some generic things that need to be in it. And then you can tailor it as much as you want. And usually one of the things that people tailor is method of burial and method of remembrance. So you can put in there that I direct my estate that, to purchase a headstone, and on it I want engraved, my name, Corinne. And that would be, none of this is necessarily completely legally enforceable, but that's why you're picking somebody important to be your executor, because you're trusting that they will make the right decision. And if they don't make the right decision, they are subject to some sanctions from the court. So if somebody else knows that was what your desire was, and if it's in your will and you don't do it, they could have some fines, they could have to correct it, it would probably get taken care of. But the point of it is that you should definitely pick somebody that, if that's what you say you want, or if you want cremation versus burial or something like that, and that's a deal breaker for you, just make sure that when it's in there, that this is specific so that they know, and so that if it comes under scrutiny, like from a family member or something like that, or from anybody else, it's really incontrovertible that this is what was in there. And now it's kind of, not necessarily the law, but it's written, it's probated, it has to be acted upon. And that would be how you would deal with that in a will. And, if you have young children, you're going to put in maybe guardian provisions in terms of, if you were to die, if the other parent were to die, this is who I'd want to take care of my children. If you have, maybe grandchildren or children, you would probably want to put in some trust provisions. You don't have to make a trust, but you would say, and minors cannot inherit in the state of Pennsylvania. So what you would want is to, along with the executor, the alternate executor, and the guardian, you'd want to put a trustee. Now, it could all be the same person, or they could all be different people. That's your comfort level. And sometimes one is not the best choice for the other, because a guardian doesn't necessarily mean it would be the best choice for your executor. They're good with your kids, but they're not good with numbers, and they're not good with money. But a trust would be, you would say who you want to take care of the assets and distribute the assets and manage the assets for the children until the children reach a certain age. And you pick the age. I mean, if you don't pick an age, it'll be 18. Most people feel that's a little young to let people inherit if they're minors. So they usually pick a little bit higher age in the 20s or early 30s, or they do it over a proportionate amount over time. So as far as what you put in the will, what you can leave it as generic as you want, saying that everything I have goes to this person, this person, this person, and this share of this percentage. Or you can specifically delineate different items and different percentages to different people. And that's something you got to give some consideration to. If you only have one person, it's not a big deal. If you have two, it's not a big deal. If you have, 20, you have to start making choices on priorities and percentages and amounts. And you can do a variety of things. You can do like the corpus of the estate, or the money, gets distributed one way, but the property gets distributed another way. The other thing I would mention too is it's, when you have a will, there you should probably, if there's personal property or things that you don't list in the will but has some value as far as sentimental value, or you want to go to specific persons, you should make a list called a memorandum. And just, it's a handwritten letter, it could be typed or whatever, just signed by you, that you just attach with your will. It does not get probated. And the advantage of not probating it is if you put it in your will, and you say, I have a diamond watch that goes to this person, that watch now has to be valued, appraised, which is a cost to the estate. And then it has to be added into the taxes that get determined in terms of the overall estate. So, depending upon how much the appraisal comes back for, it could be a little bit of a tax consequence for the estate. The better practice is to basically say, if it's just household items and you just have a desire that these things or jewelry or whatever, they do the memorandum, keep it with your will, so your executor has accessibility to it and would distribute it. And that's why the executor is so important, because even though you might have a lawyer doing the paperwork, probating it, guiding you through the court system, ultimately it's still going to be the executor who makes sure it gets done. It's still going to be the executor who makes sure that your niece gets your watch. It's still going to be the executor who makes sure that all the assets are found and distributed, and that nothing is going astray. It's still going to be the executor who makes sure your headstone has the right name on it. So that's why it's important, and that's why it's important to have a backup that's pretty much equally important. It's not a good idea to have a co-executor, like two people that make equal decisions, because then what happens if they don't agree?
So I have one child. My wife and I have one child.
Mm-hmm.
So if we want him to get, do we have to have a specific inventory in that memorandum, or can we just say that he gets all the household goods?
No, I mean, you in your case, which is a pretty simple, everything goes to your wife. In the event your wife is not there, everything goes to your son. That's all my husband and I have. Everything goes to each other, then everything goes to our son.
Right.
And if our son is a minor, so we have some guardianship provisions that two friends of ours would be our preferred choice as guardians. And we also chose them as the trustee if there was any cash or other assets that needed, that wouldn't be released to Ben when he was a minor. But in your case, yeah, you could say everything just goes to each other and then goes to my son, and leave it at that. You don't have to delineate. I'm really talking about delineation, because usually that's one of the questions I get a lot is I have some things that really don't have a value, but I really want this thing to go to this person because it has family or sentimental value or whatever. And the best practice with that is just to keep that with the will in a letter, a memorandum, whatever you want to call it, and make sure that your executor has that available to them. One of the other good points is that in this fireproof box, keep a list of your assets. This is something we should be doing anyway. You should be keeping a list of all your assets, all your liabilities, account numbers, and keep it current. You don't necessarily have to put the current balances or amounts, but one of the things an executor is going to do once you pass away is kind of go through your paperwork and figure out what you actually owned. And it's a bigger job than you think, because you think most people are organized, but most people aren't. And even though you might know exactly where everything is, and a third party might not. So you want to make sure, just to make it easier on that person, that you have a pretty comprehensive list. This is where my bank accounts are. This is where my investments are. This is the real estate I own, and things like that. And if you can put account numbers, that's probably good. If it requires a password to access an account, you should probably keep that too. And maybe that's the reason for the combination too, is just to keep that more secure so that, somebody who shouldn't have it doesn't get it. So that's also, like in my case, that wouldn't matter. But in somebody else's case, if you have roommates or if you have somebody that's a little too nosy in your life, you might not want all that information out there. So that's basically the will. And again, with regard to transgender issues, whatever you feel is important to you in terms of how you want to be remembered can be put in a will. And you can make it as specific as you want or as general as you want. If in Corinne's case, she just wants her name remembered on tombstone as Corinne, it can just be that. If there's more to it, if there's a special, a service under a religion or a special place you want to be buried, or your ashes spread, you want cremation versus burial, all those things can be spelled out. And if you don't spell them out, it's probably going to be up to the executor and or your next of kin. The next thing I wanted to touch on is there's a couple types of powers of attorney. And what a power of attorney is in the event you cannot do something, it allows somebody else to act in your place. And this is a good idea, even if you're married, even if, whether you're straight, gay, or it's especially important if you're single. But a power of attorney gives a specific person or persons, it could be more than one person. It could be, you could have a primary and an alternate in the event the first person can't do it for some reason. But it gives that person the right to do stuff for you, depending upon what kind of power of attorney it is. And there's a couple of different kinds of powers of attorney. The first one is a general, or what we call durable power of attorney. Now that can be very specific, or it could be kind of general, just as the name says. And that's saying that in the event I cannot do something for myself, this person is empowered by me to manage my bank account, to pay bills, to do whatever. And you can add in a million things if you want, or you can just, make it very generic and say, take care of financial matters. And that is a good idea to have, even if you're, generally, it used to be that they would always turn to your spouse or your life partner or whatever to make these kind of decisions and just to act for you. That was just the custom. However, banks and lending institutions and pretty much anybody would need to, sign something or manage something with is not going to necessarily trust that that is the person that should be doing it, even if it's your spouse. So they're going to want a legal spouse under the law. They are going to definitely want something that says, in the event I can't do this, this is the person I want to do it. And then the other thing is that there's another kind of power of attorney, which is called a healthcare power of attorney. I think this is really crucial. I think everybody should have a healthcare power of attorney. The medical system is very hard to navigate, and it's not there for somebody to make a decision for you if you can make that decision on your own. But if you're too sick, if you can't communicate, if you are comatose, whatever, and you can't communicate for yourself what you would want in a life-challenging event, or for medical care, or for possible treatment plans, this is the person you're designating to speak for you. And it's really crucial, because even if you're a son or a daughter of somebody or a spouse of somebody, it is not guaranteed that that person will get listened to unless they have the legal right to speak for you. And so it's pretty important. And again, you can have as many as you want, an alternate, as many alternates as you want, but it's really crucial, I think, that everyone have something to say. If I'm unconscious or I can't act, this is the person I would want to make these medical decisions for me. Corinne brought up before when we were talking that, for transgender people, there's also a certain way you want to be treated, how you want to be referred to, how you want to be remembered. Well, a power of attorney, a healthcare power of attorney, is basically while you're alive. But you could put in there that, that these are the things that I want. I want to be known by, these pronouns. I want to be, my name is Corinne. I want that to be my name in all my medical records. I want my gender to be identified as whatever you identify as. It's something that would give that person the power to take care of those things with the administrators or the people they'd have to deal with in those situations. It usually applies to either a healthcare facility or a nursing facility or a hospice or something like that. But it is really crucial, I think, even if you're in great health right now, if you're in a car accident and you're comatose or you're not able to speak, and they're going to turn to who, if they don't have anybody to turn to, you don't know they're going to make the right decision. And if you have a third cousin come and your life partner and your somebody, another relative or a friend, they're not going to want to make that decision. And even if it is your spouse, they're going to make sure that this is still the person you would want to make that decision for you, because, family situations change, relationships change. There's first spouse, second spouse, sons and daughters from first marriages, second marriages. They don't want to be put in that position. And it's very difficult to navigate the healthcare system. I learned that the hard way with my parents, and I was an only child. And if I hadn't had a power of attorney for them, I would have run into a lot of more difficulty than I did when they got to the point when they needed me to speak for them, even though that's what they wanted.
So even as an only child, right?
Mm-hmm.
I mean, you were the only person to be making decisions.
Right.
The power of attorney is helpful.
It was very helpful in my particular case because, I was dealing with a nursing home. I was dealing with doctors. I was dealing with a hospital. I was dealing with a hospice eventually. And I think the thing is that people are generally willing to listen to you, but they're not willing to necessarily act upon what you say unless you are the person who has the authority to make this decision. And just as a personal anecdote, I remember being on the phone with a doctor about my father's care, and it was nothing confrontational, but I had kind of objected that they hadn't notified me because they had moved him and from one kind of unit to another unit, and no one had notified me. And I got a doctor on the phone, and I don't think I was being aggressive about it. I just said, I wish somebody would let me know. And they told me, we didn't have to leave because, who are you? And I was like, I'm their son. And they were like, it doesn't matter. I said, I'm their power of attorney. And then they're like, okay. And then they started talking to me. So I kind of realized you could get a jerk too that's going to say, you don't have a right to make a decision for this person, and we don't have to talk to you. And then as soon as you say I have a power of attorney, they're kind of legally bound now, or they are legally bound now to have to deal with you. And I think that's true no matter what your situation is. And in my situation, it was pretty clear. In my spouse and with I, it's pretty clear, but still we have powers of attorney for each other. And I wouldn't just assume that just because of that, it's going to be the person that they choose to. I would also say that I lost my train of thought, but it's just a very good thing to have, because you don't want to take the chance that somebody's going to do something that you don't want them to do, or not do something that you would want them to do, or that your estranged brother all of a sudden shows up on the scene and says, this is not what Corinne would want, and then makes a completely different decision. And they listen to because they have a blood relation, and that's what their choice was.
Yeah. So I'm going to get to Kirsten's question in a second here, but I know that for myself as a woman of trans experience, who happens to be the owner of a penis, that I'm afraid that I'm going to be placed into a nursing home at some point, right? And I want to be in the women's wing with the other ladies. I don't want to be in with the dudes, but that decision will be taken away from me.
And that's why you need you should put it in your healthcare power of attorney that this person is also able to make those kind of decisions as to how your identity will be identified for medical records, for medical purposes within the facility, that you will, you identified as a woman and you want to continue your life as a woman. And I think the only real, you don't have any protections, I guess, universally, but the best protection you can have is probably have it in your healthcare power of attorney that in the event that I am incapacitated, this is my wishes, these are my desires, and I hereby instruct my power of attorney to do whatever's in their power to make sure that these are complied with. And that would at least give some authority to the power of attorney to make sure that happens. And if it didn't happen, it would also give the power of attorney some recourse, because let's say, the hospital says, we don't really care, that's just not our policy here. Well, now you have a document that says this is how you identified, this is what you wanted. And you now have a person who's authorized to act for you. They have to treat that person as if it's you. And if they don't comply with the wishes, then there could be some legal ramifications. So it's about the best you're going to be able to do to say, guarantee these things. And
so I think that the message there is, and I think that in the US, certainly where, often elderly people, are on Medicare, Medicaid, and they don't have a whole lot of choices about where they
right.
Are placed sometimes based on cost, but is that if you have the opportunity to,
right.
Start nursing home shopping early, I guess.
Yeah, that would be good, I guess, if you could. And even in the event, you do have a little bit of a choice, I think. You're right, there's probably not a great amount of choice, but you may have a choice about which, like you said, which room, which roommate, which wing, who you're housed with. And I would think that, they would tend to go by what your wishes were as opposed to what maybe your birth gender was, if that's how you identified. And they won't do that if there isn't some direction and somebody to speak for you. If you just happen to go in and don't have a power of attorney and you haven't made these plans in advance yourself or can't speak for yourself, they'll do whatever they want to do. But if you have a power of attorney to speak for you, it at least gives you some protection and about as much recourse as you could have to force somebody to do something they may not want to do. And you might have you probably have some legal recourse too. Does that answer that question?
Yeah, I'm not sure it's the answer that I wanted, but it's the best
What did
answer.
you want? You wanted to
I wanted that they have to do what I tell them to do.
In theory, that's what you're doing. But in reality, I can't, I guess as an attorney, I know there's always two sides to a story, and I don't want to make guarantees. I think the thing is what you can do to protect yourself as best you can is to say, this is what I want, and this is the person I want to accomplish that goal if I can't speak for myself. And then it would be the same as if you can speak for yourself and you're in a hospital ward and they're making decisions based on your birth sex as opposed to your assumed sex. So maybe, you would have the same voice as you and could make the same amount of ruckus as I know you would. And people would have to listen to you. So it's nothing in this world is a guarantee. It's about as best as you can do though. So, and it's not something that would necessarily just be tossed in any power of attorney, either healthcare power of attorney. That would be something that you would tailor yourself based upon your wishes. Okay. So when you're talking to your lawyer or if you're drafting one, and sometimes they have a lot of forms for this at the hospitals and stuff, make sure that if there's any, like places to comment, you're putting this kind of stuff in. There's usually a place that says, special requests, and that's what would be put in it at that point.
Well, I appreciate you acknowledging the fact that I would raise a ruckus because I'm
I have
pretty good ruckus raiser.
And if it happens, just call me and I will be there.
I know.
My Bossy and Bradbury Sullivan, and I will get Liz Bradbury to kick asses. So but I've been through this for 34 years and things have gotten a lot better. And, the fight used to be that, same-sex couples couldn't get married, so the partner never had any relations, so therefore they were excluded completely.
Right.
And family members would come in and say, well, they're not family. They have no right to be here. They have no right to make decisions. And if they didn't have any legal paperwork to say they had the right to make those decisions, they were excluded. So, for 34 years now, I've been doing powers of attorney for same-sex couples and everybody else. And I think transgender is a little different, but it's the same thing. It's just like, this is what you would want if you could speak for yourself. This is what you want the people of the world and the people that are dealing with you and the people that are, caring for you to know that this is what you want. And that has some power to it. And it also has, an ability to be somewhat enforced. If you have a power of attorney and they get rebuked by the nursing home administrator, they can go to court and they can say, this isn't fair. This isn't what Corinne would want. And here I can prove it. Here is the power of attorney that specifically delineates this. Or, and as far as the headstone goes, whoever's going to pick out the headstone probably gets to make the decision. You just want to make sure that the person who picks out the headstone is influenced by the executor and directed by the executor.
Right.
So
we did have a question here, and
sure.
Or I guess it was a comment, but I think I'll turn it into a question.
Okay.
Where this person owns a couple of animals. It's a horse and a dog, and they're like they're buddies, right? They're inseparable.
Right.
And so if you have animals, right, and you want those animals to be housed appropriately, to your wishes, you can determine that in your will as well.
And I've done that already, where people like set aside a life insurance policy or a trust or whatever for a specific care of a dog, or they give a certain amount of money to a certain friend so that friend can take care of the dog or whatever it happens to be. You can put those in there too. The clause I really hate is there's a clause, it's a generic clause that says, I want all my pets euthanized when I die. And I never quite understood that. And I haven't really had to use it in years, but but generally people want their pets taken care of. And again, that would go in your will. It would basically say any pets when I die, any pets I have, this is who they should go to. And if you want to set up money for that person, you should say, a percentage of my estate can go to this person, assuming they get my pets so that they can take care of my pets. Now, you don't have to put the monetary provision in. You could just say the pets go to that person. But, sometimes one goes with the other. Like, people don't necessarily want to burden somebody financially just because they're a nice guy and they're taking care of your pet after you're dead. But those are things that all go into the will, and those are legally enforceable, and they take priority over a lot of other stuff. Like, that stuff would get done first before the rest of your assets would get distributed, because those are specific requests. I mean, once you get done with all the specific requests, then you're starting to divvy up whatever's left. But so that, those are important, and I've done that, and that it's not that hard to do. It's generally, I do ask people that question when they come to me, and because gay men and lesbians love their animals too. So and then the other thing I would recommend that everybody get, two other things, and then I'll go on for more questions too. But I would recommend that everybody get a living will. Now, a living will is also called an advance directive. And this is also something, if you go in for any kind of medical procedure, or if you go into a nursing home or whatever, that it directs what you would want in the event something goes horribly wrong, or you're at the end of your life. And the most common questions I get on that is like, well, what if there's a chance I'll recover? What if I have a heart attack and I have a living will? Does that mean they're just going to pull the plug on me? That's not the point behind this. The point behind this is that there has been a medical determination already made that you're gone. You're brain dead, you're vegetative, you are never going to recover. They could do things for you, but it's never going to get your life back. Under medical science now, they could keep your body alive for a long time with artificial respiration, artificial feeding, and just, it could go on for years. I mean, the reason that these came about was, if anybody's old enough to remember, there was a case in New Jersey with her name was Karen Ann Quinlan. And what happened was, I think she was in a car accident and she was married, and her parents wanted to use every means available to keep her alive. And she was comatose for years. And her husband said, that's not what Karen would want. And there was a big fight because there was no documents, there's no powers of attorney, there was no living wills at the time. For the most part, it was kind of an untested concept. And they went through like a 20-year legal fight over who had the right to make this decision. Should be the parents who spent the majority of their life with her, or her husband who had spent a shorter portion of his life with her. And the end result is that you really should, for the benefit of your heirs and the people that are going to be left behind if something like this would happen, put it in writing what you would want. That if there is no hope of recovery, I don't want to be kept alive. I don't want any extraordinary means used. Meaning that ordinary means, if a doctor's goal in life, their Hippocratic oath is to do no harm, to keep you alive. So at the point that they're saying that this person has no hope, that they've already made a decision that it's not going to change anything, and we can keep them artificially alive, but we can't bring them back, and they're never going to be the same. Even if we keep them, even if they're off life support, they're never going to wake up from this. So a living will is a good idea. Now, it's not necessarily legally enforceable. But what it is and you're not necessarily directing anyone specific to make this decision. You're saying, this is generally what I want. But the reason you want to do it is, and I'll use a personal example again. I did a living will for my parents when they were probably in their 70s. And at the time, the forms were different. At the time, it gave you choices of what you did and did not want. That's kind of not the way it's done anymore, but at the time it was still kind of a young thing. And I remember I checked off as the dutiful son a few things my mom may want: penicillin, blood transfusions, things like that. And when my mom saw it and she read it, she took a pen and she crossed everything off. And she got it. She understood. She said, if I'm not going to get better, I don't really want anything. Why would I want something to, not cure me, but just because I could have it? So she crossed everything off. And then, 10 years later, she's in a hospice. She had had a stroke. I'm an only child. I have a certain amount I've tried to keep my parents alive for a large part of their older life. It's a hard decision. But then, I realized it wasn't my decision. It had already been determined that my mom was more or less gone. She was in her 80s. She had had a stroke. She had had congestive heart failure. The stroke had pretty much taken away everything, and she wasn't coming back. And at that point, it was much easier for me to let it go and say, well, this is what she would want. So it's for the benefit of those who are surviving. And it is legally enforceable if there's a contest. If there were a Karen Ann Quinlan situation where it's your life partner, your spouse versus a parent, and they're going to go with what your living will says. And if they don't, it could be taken to court, and the court's going to go with what your living will would say. So, and it's good to have that, and I think it's just a good practice to have it. The one other thing I would say that people should have, especially people who are not married. Pennsylvania has a lot of peculiar undertaker rules and funeral director rules. And really the rules say that the only person that can make decisions, and this again would go back to the headstone if that's part of the deal with the Undertaker, is that it's either your next of kin, which doesn't necessarily have to be the closest either, or the person you put in writing that you want to do and make this decision. So if you're not married, but you've been in a relationship for 20 years, and this is the person you would want to make final arrangements for you. This is the person that knows you best and knows you would want Corinne on your headstone. That's the person that should be making the final disposition, quote unquote, of remains plans for you. And if you put it in writing, it's a very simple form. It just basically says, in the event of my death, this is who I want to make these decisions for me. And again, you could flourish that and put in very specifics. I want my headstone to say Corinne. I want this read at my funeral. I want this song played. I want my ashes spread here. And that then gives authority to whoever is actually carrying out those wishes, from a practitioner standpoint, like an undertaker or funeral director, to do that for you. And if a family member then comes and says, well, no, that's not what we want, and we're next of kin, they're going to say, no, it's too bad. This is what Corinne wanted. This is what this person wanted. So it's a good thing to have. It's come up a few times to being associated with the Bradbury Sullivan. We've had it a couple times where there have been people in long-term relationships and they haven't really made these plans, and then they're getting held out of hospital. Their partners are getting held out of hospital rooms. People are not able to make these decisions regarding, and family members aren't always forgiving or always accepting. So a lot of times, if it's not there, it's going to be the family members that rule. And then you're not going to get Corinne on your headstone. You're not going to get referred to as she in your eulogy or in the newspaper articles written about you. But if you give somebody you trust the ability to do it, then it's likely, probably definite that that's what's going to happen. So,
so there were a couple other questions. Interesting. So it's a really interesting one, and the person who wrote it is from Canada, which may be different too. But
I don't know.
What about a
state law? But I'm assuming state law is pretty much the same everywhere.
Yeah.
But you can ask the question. If I don't know it, I don't know.
So the question is about voting proxies for elections.
If you have a power of attorney, you should be able to do it. You would have to touch it. Yeah, you should be. If somebody's in a nursing home and can't, do it for themselves, you should be able to do it. I mean, I think that would probably depend on the municipality where you're at and the type of election, whether it's local or federal. And in Canada, I can't answer what their, I don't even know what their elections are like. But, power of attorney, if your power of attorney directs that person can do it for you, they should be able to legally do it for you.
So my spouse could vote in my stead if I was incapacitated.
If you gave them a power of attorney to do it. I mean, I'm sure it would raise some eyebrows at the polling place, but the legal authority for it would be that person has the power to act for you. That's
but you would have to be specific, and that's what it's.
Yes, it couldn't be a general power of attorney, I don't think, for that purpose. If it dealt with like a financial matter and it just, your power of attorney is financial, I think they would take that generically to mean any financial thing. If it was selling a car, maybe that's a financial matter. Voting is a little bit more personal. And I'm not so sure that if you didn't have it specific that they would honor that. But I think if you put it in specifically, there's some legal authority to say that has to be carried out.
Wow, that's interesting. Especially with all the crazy stuff going on with voting nowadays in the US. So I know the answer to this question, but I'm going to ask it for the benefit of our audience, which is, so if you've had your name legally changed, as I have, but let's say that you haven't updated your will to reflect your new legal name or your DNR, your living will, or any of these other documents, power of attorney, what happens?
Well, it's still you. I mean, a name is, and I hope this is the right answer, Corinne, from your perspective too, but I mean, it's still you. I mean, people change their name when they get married. It doesn't change who they are. If you change it should be updated. I mean, the thing to take away, the takeaway is that you really should keep these documents current. You don't have to do them every year, but every 5-10 years, review it, make sure they're right. And if they need to be updated, update them. And a little known thing that most attorneys are not going to tell you either is that Pennsylvania is a holographic will state. And what that means is that we accept handwritten changes and we accept handwritten wills. And the reason attorneys won't tell you that because we want to make ourselves indispensable. But bottom line is that if you happen to have an outdated will and it has an old name, a dead name, as Corinne referred to it as, just cross it off, initial it, and date it. And as long as you do that above the signature line, it's as effective as if you had rewritten the whole thing. Now, if there's more changes than that, I would suggest you have it reviewed and change it. I mean, you don't want it to be too many changes that it's confusing as to what you're looking for. But if it's a simple thing like that, a name, my suggestion would be whatever document it is, correct it to what it is in your own handwriting. Don't type it. Do it in your own handwriting. Don't white it out. Cross it out in your handwriting in a pen and initial it and date it. And that should be effective enough. That would act as an immediate edit to the document.
Okay, that's wow, you just saved me a lot of money. That's excellent.
I know, and I just eliminated myself a fee. So
this is why we love you. So, but the thing that's important, I think, is to understand is that, whether it's a will or frankly a car registration, right? It's still for the person, right? And while you should update all that stuff, if you haven't gotten to it yet for some reason, the world isn't going to come to an end.
No, and a lot of people, sometimes I don't know why, but most will forms ask for your address too in it. And I know why. The reason behind it is so that they can figure out where you were living at the time you made it and, make sure that's the same jurisdiction that you are at the time you die. But realistically, that, people worry, well, what if I move? Is it going to be effective? I mean, the answer to that is if you leave the state, you probably want to check in the new state what their laws are. Pennsylvania is based on Old English common law, and it hasn't really changed in hundreds of years. I mean, it's the language has updated, but the principles behind it haven't. Most of the United States is the same way, with maybe the exception of Louisiana, which has Napoleonic law. So I would say that it's a good idea to have it reviewed, but it's minor changes and things like that. You are who you are, even if you haven't changed all your documents, and that's pretty common. Sometimes people change their name and they miss something or they forget about something. They don't get a new birth certificate. They don't change all the documents because it's a hassle. It's gotten a little bit easier recently, but it's still a hassle. And that doesn't change the effect of it. And again, I think the easy, self-help solution is just make sure it has to be initialed and dated, and it cannot be below the signature line. You can't put like an asterisk at the bottom and say above everything's changed, because anything after the signature is not valid. So as long as it's above, and this is just based on English common law, so it should apply universally throughout the United States. Again, I'm not so sure about Louisiana because I'm not so sure about Louisiana in general. But other than that, that should be good. And, but you're right. You are who you are. It doesn't change the fact that if you move and you have a different address, you're still the same person. If you've changed your name, you have the same person. And you got to think too, in heterosexual couples, a lot of times women used to assume their husband's name. And, they didn't go back and change everything usually. So, but they still, they managed and everything got, taken care of in the end.
Great. So generally speaking, and I realize that every situation is unique, but if you were to, if one of the people who are attending were to come to you and say, I need, the package, right? I need, the will, and I need the durable power of attorney. I need a living will, round figure. And I know that every person is different and every.
Yeah. You know what? It isn't, it isn't that different, to be honest with you. I mean, it depends on what you're asking for. If you're asking for the package, which is pretty much what I try and encourage everybody to do, because I think it's kind of crucial that everybody have everything. If you're squeamish about a living will because you just don't like the idea of it, okay, you don't have to have it. But I think it's a good idea, and I'm going to encourage you to do it. And the price could come down a little bit with that. Generally, what we charge is between $350 and $400 for the entire package per person. I usually, if it's a couple, if it's people who are living together, people who are married, and it's going to be reciprocal wills because they're going to be more or less mirror image. It's just going to change the names. I usually deduct about $100 from that. So if it were $800, I'd make it $700. And that's pretty much, it depends because I'm pretty cheap too, I'll be honest with you. I know I had friends who live in New Jersey. It's two men and they're getting married and they just did a will package with powers of attorney and everything. And I was curious and I said, how much do they charge you? He said $2,000 each. So $4,000 to do basically that. And that was kind of outrageous. They also live outside of Newark or Trenton. And, it's a little bit more metropolitan. I think it's a little higher income community. So I guess that's the going rate. Locally, I would say it varies. I would say 400 is pretty reasonable. I would say, I asked somebody recently what they had paid because they were getting revisions and they had paid 700 for just one package. So that was a while ago too. So I think 400 is pretty reasonable. I think you should expect to pay somewhere between, like 300 to 500, probably under 1,000. It shouldn't go over 1,000. And if you're doing a comprehensive, very complex estate plan, that's a little bit different. I'm not an estate planner. I don't make decisions of how you should invest your money and how you should set up a trust and like that. I just implement what your desires are when you die. An estate plan basically means there's a lot of money or there's a lot of assets that need to be divided and they need to be managed. And maybe some are going to be sold, maybe some are going to be inherited. And you're trying to figure out what the best tax consequences are. Most estate planners, some of them are attorneys, but some of them some of them are more financial planners that work in conjunction with attorneys. I don't get into that because that's a field in and unto itself. I'm more basic, like, the average person, what they would need. But if you're a millionaire and you have many assets and you have a corporation and you have 6 children and you're setting up trusts and stuff, that's estate planning and that'll cost more and that will probably be a lifelong process, not just a one-time trip.
Great. Well, we're going to give people a moment or two just to see if there's any additional questions.
Okay, sure.
But while we're just waiting to see, Mark, I truly appreciate you spending the time with us tonight. And
I was worried I wouldn't have enough to say, and I guess I'm a lawyer, so we can always talk as long as you give us.
Well, so, between the two of us, we'll make it work, right?
You had said that, just while we're filling the time, you had said about a DNR, to just in passing. A DNR is a medical form. I've been getting that question a lot because people are equating a DNR with a living will. And they're not the same thing because a DNR is basically do not resuscitate is a medical instruction. It takes a doctor to sign off on that. So that is something a healthcare provider should be providing, or a nursing home or a hospital or whatever. That's something that they should be providing for you. A living will is, if there's no hope of recovery, this is what you don't want. You don't want extraordinary means. But people come saying, oh, I want a DNR too. And, the reality is that we're not doctors. We can't do that. All we can do is put it in, your wishes that you don't want to be resuscitated as far as the power of attorney, as far as the healthcare power of attorney goes, as far as your living will goes. And I told Corinne when we started for the first time, I just did what somebody asked me to do, a Catholic power of attorney. And I had never really heard of it. And then I looked into it and there actually is one and it's recommended by, certain dioceses. And it really is just a basic power of attorney, but it was flourished out with, that having people pray for you, respecting your wishes as a Catholic. So that can be done in any kind of power of attorney, can be tailored to you specifically, not religiously, but specifically saying, I identify as a woman. I want to identify and be identified as a woman going forward. And it should be enforceable as best as it can be.
So we did have one question, and that is, how is debt dealt with? I'm guessing, if you pass.
Yeah. What happens is that when an estate is probated, you first have to pay all the debts. So if there is debt out there, theoretically, that's supposed to be paid first. Realistically, what happens but you figure out what the debts are and you try to compromise them. If there's credit cards, they usually take far substantially less than is owed. And a lot of times, if you're dead and you just prove to them, the executor just proves to them you're deceased, it just goes away, it just gets closed. So a lot of like the non-secured debts go away. Medical bills and stuff like that, we deal with whoever the care provider was, and they tend to compromise them pretty significantly too. And so you're paying pennies on the dollar just so they get something, and those get paid first. Mortgages and things of that nature, I mean, they're attached to the property. So if the property is being inherited, that's going to have to be satisfied by the estate before it gets inherited. So, and it may end up, changing the estate plan. Now maybe the house can't be inherited because there's too high of a mortgage on it. But theoretically, all debts are supposed to be paid for first, and then assets distributed. And debts, what they're really talking about is the taxes. Now, there's usually not federal estate tax unless you have several $1 million worth of assets to be distributed. So you're really talking about Pennsylvania estate tax. And from spouse to spouse, or from spouse to child, or from parent to child, it's not a taxable event, it's zero. But the further you get removed from that, if you're giving, non-charitable organizations, if you give your church or another nonprofit, there's no tax effect on that. But if you're giving it to private individuals, you're giving it to cousins, you're giving it to brothers and sisters, depending upon the degree as to which they are related to you, there's a different percentage of tax for everybody. This changes this changes year to year because they reevaluate the percentages, and I don't really know. I know that the furthest percentage right now, I think, is 14% for a non-relative, which is a stranger or, somebody that has no kinship to you. And then the least percentage is a spouse or a child, which is zero.
So if a debt is secured by property, so that would be like a home or a car, right? Or a camper or something like that, then that debt is secured by the property, and you may have to sell that house in order to pay off that debt.
It's really the estate's responsibility to get rid of the debt. Yep. So it's the estate's responsibility to either, compromise the debt somehow or get it paid off through whatever else is left. Because, if the intent is that person gets the car, the intent is still that person gets the car. And if there's a debt associated with it, any money in the estate first goes to pay that debt, and then that car would be free and clear to whoever's supposed to inherit it. The problem would be is that if you have an insolvent estate, which happens a lot of times, because, a lot of times it's just there isn't anything to divide after you get done paying all the debts. You just have to prioritize them. And there's a certain priority to stuff. There's a statutory priority, and usually it's the secured stuff that gets the highest priority. Unsecured things like credit cards and stuff like that really have no priority. So it's whether they even get paid is questionable. But it is the responsibility of the state to try and take care of the debt. And most of the time when you're dealing with somebody else, they realize that they're in a precarious position, like a lender, that they may not get anything. So they're usually pretty willing to negotiate and lower it substantially, especially like credit cards and medical care providers, because they're looking at getting nothing. So if you offer them, $1,000 for a $10,000 bill, they're probably going to take it.
Okay.
We found anyway.
That's good to know.
A lot of times they're really willing, as soon as you say the person died, they just says, okay, we'll close it. I'm kind of surprised by that. Happens more often than not too.
Wow. Okay, good. All right. Well, I think we come to the end of our time. So Mark, thank you so much.
Oh, it's my pleasure.